Got some big news today as another court has sided with the Second Amendment. It's a shame that that's breaking news, but here we are. Before I jump into this, I did a video earlier about Everytown for gun safety infiltrating the gun community. Everybody should be aware of that. Watch that video. It's floating above. I'll put it in the description below in the pinned comment. Watch that. Share it. Keep an eye out for that. All right, guys and gals, my name is Jared. Welcome back to Guns and Gadgets, the premier source for Second Amendment news you won't find anywhere else. Today, I'm diving into a major decision out of the 10th Circuit Court of Appeals. At the heart of the case, New Mexico's controversial 7-day firearm cooling off period, 7-day wait. The state said it was about safety, but the court just said otherwise. By the end of this video, you'll understand what the case was about, what the judges decided, and why the ruling could have ripple effects across the nation. Real quick, a huge thanks to CMMG for sponsoring today's video. If you're looking for a workhorse of a tool with a reliability and dependability that you can trust your life to, whether it's home defense or competition, CMMG's tools are top tier. They make great parts and conversion kits. You've heard me tell you I've taken my Banshee across this nation for years on end now, and it's also replaced my previous home defense tool from a different brand. I've even paired it with a CMMG zeroed quieting tube, and it's phenomenal. American-made quality you can depend on. Be sure to check them out and utilize code GNG10 for a very nice surprise too. So here's the story, guys and gals. In 2024, New Mexico passed a law requiring a mandatory 7-day waiting period for nearly every firearm purchase. Now, the governor, Michelle Lujan Grisham, you've heard her name here on this channel for years, she wanted a 14-day wait, but lawmakers opted to go with 7 instead. No exceptions. Even if you passed your background check instantly, even if you were a retired cop or you were in immediate danger, didn't matter. You had to wait a week. Now, the law carried criminal penalties if a firearm was transferred before the waiting period ended. There were a few carve-outs that existed, like active law enforcement, concealed carry permit holders, and family-to-family transfers, but for ordinary citizens, the rule was ironclad. Now, the state argued the law served 2 purposes. Number 1, reducing impulsive acts of violence or suicide. And number 2, closing a perceived loophole in federal law where background checks can sometimes take longer than 3 days. But almost immediately, New Mexico resident Samuel Ortega, a retired law enforcement officer, and Rebecca Scott, they filed suit. Now, both had tried to buy firearms, both passed background checks on the spot, and both were forced to wait 7 days solely because of this new law. And at the trial level, the federal district court denied their request to block the law. The judge there said the right to keep and bear arms doesn't necessarily mean the right to immediately acquire them. Somebody should do a urine test on that judge. He also said that waiting periods are presumptively lawful commercial conditions under Heller, which is wrong as well. Also said historically there were restrictions on gun access that justified modern waiting periods. Again, somebody do a drug test on that judge because he's smoking something. All right, so the plaintiffs appealed, and that brings us to today. The 10th Circuit made a ruling today. And here's where things get interesting. The 10th Circuit reversed the district court and ruled in favor of Ortega and Scott. Judge Timkovich, I'm hoping I'm saying his name right, he wrote for the panel, laid out several key points. Number 1, the right to acquire is part of the right to bear. Just like the First Amendment implies the right to acquire a printing press, or the right to religious freedom implies acquiring a Bible, the Second Amendment necessarily covers acquiring a firearm. You can't keep or bear what you can't obtain. Number 2, waiting periods directly burden Second Amendment rights. A flat 1-week prohibition on possessing your firearm, even after you've cleared a background check, is a restriction on the right itself. The court compared it to forcing newspapers to have to wait a week before publishing, or requiring church closures during COVID-19, right? It was a violation of the freedom of religion. Temporary restrictions on rights are still unconstitutional. Number 3, not a presumptively lawful condition. Now, the court said New Mexico's waiting period wasn't like other conditions, such as background checks or age limits, because it wasn't tied to any action or qualification. It was just a blanket delay. In other words, you couldn't do anything to shorten it, and it wasn't about ensuring someone was law-abiding. It was a simple, time-based effort, and therefore not protected under Heller's carve-out. Number 4, the judge said, no meaningful historical tradition existed. The state pointed to intoxication laws, permitting systems, and group bans from the past. But the court said none of those were remotely comparable. Now, waiting periods are a modern invention dating only back to the 1920s, and they've only been adopted in a handful of states. That's too new, too rare, and too broad to fit the historical tradition that standard that was established under Bruen and reaffirmed under Rahimi. So why is this important? Well, first is precedent, right? The 10th Circuit made clear that acquisition is part of the Second Amendment. We know that, but there's judges, again, that should probably be tested, that are trying to just push the anti-gun agenda. And that's huge. That means future challenges to gun control laws dealing with sales or transfers will have strong backing. Second, waiting periods, those laws nationwide are now on shaky ground. California has a 10-day wait. Hawaii, Minnesota, Washington, same thing. Now, several other states impose delays of 3 or 7 days. And this ruling says that those laws probably don't stand up under Bruen's historical test. Third, this case reinforces the principle that Second Amendment rights aren't second-class rights. The court directly compared it to the First Amendment and others. You don't make someone wait to speak, you don't make them wait to publish, and you certainly don't make them wait to worship. The same logic applies to bearing arms. Now here's the kicker. This is just a preliminary injunction right now. That means the 10th Circuit has temporarily blocked the law while the case proceeds. But the reasoning here signals where the final decision will likely land unless the Supreme Court steps in first. And with challenges already brewing in states like Maine, California, and Illinois over waiting periods, this decision could quickly become part of a nationwide wave of litigation. It is important to understand, however, that the decision does not take immediate effect, as the 10th Circuit's mandate has not issued yet. The state could seek en banc, which is a full court hearing of that decision, which could delay issuance of the mandate. Now, according to the court's rules, the earliest a mandate could be issued is 21 days from today. So the preliminary injunction is in effect, but there is no ruling saying that the law is done yet. But, stick around because it's going to happen. So to wrap this up, the 10th Circuit just struck a major blow against New Mexico's 7-day firearm waiting period. The court said it burdens the Second Amendment, it isn't backed by history or tradition, and it doesn't fit the presumptively lawful category under Heller. This is a win, not just for New Mexico gun owners, but for potentially all Americans facing arbitrary waiting period laws across this nation. What do you think? Should government be able to make you wait to exercise your rights? I'm preaching to the choir, but there's always somebody who has the other point of view, and I welcome your comment to see if you can try to convince us otherwise. Drop your thoughts in the comments down below. And as always, if you found this breakdown helpful, hit that like button, subscribe to Guns and Gadgets, and share this video to keep others informed. YouTube won't do that for us, so as the creator, I ask you to help me, please, and thank you. Stay safe, stay free, and I'll see you on the next one. Take care, y'all.